Hello, my name is Carla Sanchez Adams. I'm a senior attorney with the National Consumer Law Center. And today I'm going to be talking about coerced debt and identity theft for the North Texas Coerced Debt Pilot Program. Today, you will learn about how to define identity theft under Texas law and understanding how coerced debt correlates with identity theft. You'll learn how to screen for coerced debt and how to dispute coerced debt. So first of all, to understand coerced debt and identity theft within the context of coerced debt, we need to understand domestic violence and economic abuse. Domestic violence occurs in intimate partner relationships. Usually it's in the context of other forms of coercive control. As you see this wheel here, it is using all different types of behavior to control another person. It's defined by Evan Stark as a pattern of violent acts and their political framework, the pattern of social, institutional, and interpersonal controls that usurp a survivor's capacity to determine her destiny. Battering is linked with social inequality, the systemic nature of oppressions in a particular relationship, and violence is but a moment within a larger context of coercive control. So as you see here, this power and control wheel, there's all different types of acts that include economic abuse, which we'll be focusing on today, but it also can include using emotional abuse, psychological abuse, which is very, very common, isolation, minimizing, denying, blaming, or gaslighting. If there's children that are as a result of the relationship or even from a prior relationship, using those children as a means to control and to force in a way the survivor to do something because of this coercive control. Using gender privilege and other types of intimidation, which can include even spiritual or religious abuse, saying, our religion says that you must do X, Y, and Z, and so you can't question me, you must do these things. So economic abuse is one piece of that wheel, and economic abuse is defined pretty broadly. Here it is defined as behaviors that control a person's ability to acquire, use, and maintain economic resources, thus threatening their economic security and potential for self-sufficiency. So this can look like not allowing someone to go to work, for example, or sabotaging them at work. It can include things like depriving access to assets the survivor may already have. So if it's a retirement account or a bank account, not allowing them to access that, or it can include things like, in many of my clients' cases, requiring them to deposit their paycheck into a joint account, but only the abuser has access to that account, depriving the survivor from knowing anything about the financial situation that the household finds itself in. So any debt, any credit, any loans, even if the survivor is on those loans or on that debt. And so economic abuse, because it is so broad, it can cause so many different impacts in the short term and in the long term. This is coined by Erica Sussman and Schoner of the Center for Survivor Agency and Justice as the long-term or the economic ripple effect of domestic violence. So during the relationship, it can include things like, as I mentioned before, job loss, so preventing the survivor from going to a job, sabotaging the job so that they lose it, credit damage, and we'll focus on that a lot today. Theft, so stealing money, stealing assets, incurring debt, causing the survivor to incur debt in order to be able to avoid some of those coercive control patterns, that type of abuse. So, not going to school is another form, like foregone professional advancement. So requiring them to quit school. I had one client, for example, who the abuser coerced her into taking out student loans and then prevented her from being able to actually go to school and use those loans for himself. And then at the point of leaving a relationship, then there's also an economic impact of having to pay for relocation costs. So new housing, new job, transportation. If the survivor and the abuser were married, then costs associated with a divorce, with separation, legal fees, things like that. Um, and in the short term, after leaving that relationship, it's those foregone wages of the job that they had that they no longer have and have to get a new job, that housing instability, increased cost of independent living if they were sharing expenses. And now there's an independent, the survivor's independent and has only her source of income. Then, of course, there's lifetime impacts, mental health effects after the trauma, that from foregoing any professional development, then that kind of slowed delay and the impact on that person and increased vulnerability to future abuse. So domestic violence can lead to poverty, and poverty leads to increased vulnerability. So some of these impacts are really felt through the way that our society now operates. Unfortunately, almost every type of transaction that consumer financial transaction relies on credit reports. So if you have damaged credit, if you have debt, that impacts your ability to get any cell phones, utilities, any loans for, transportation costs like an auto loan, or even for rental. They use credit reports for tenant screening, for jobs and employment screening. They also use credit reports. So that can have an impact on their ability to be financially stable, to be able to get that new job, to be able to get that housing, to be able to get that car that will allow them the mobility to be able to go to work, to drop off the kids at daycare, to go to school, things like that. So coerced debt is a form of economic abuse. As we've shaped and framed this issue, domestic violence, and then is very broad. And then within that very broad coercive control, you have economic abuse, and economic abuse itself covers many behaviors. But one of these is coerced debt. So if you had a Venn diagram, the coerced debt would be within the economic abuse, but it wouldn't be all of economic abuse. And coerced debt itself is defined as any non-consensual credit-related transaction that occurs within an abusive intimate relationship. And there is, as I've noted here in the PowerPoint, there is the notion from where this term came from, was described and was studied within credit-related transactions. But I also see this, and we also see this, those of us who work with survivors in other contexts. So depletion of assets, as I said, stealing money. So that could be from, or non-credit debt. So toll roads, parking debts, things like that, that aren't technically considered consumer credit, but still have an impact because they, either deprive the survivor of assets by taking money or cause them to be liable for some kind of debt. So within coerced debt, there's two buckets or two mechanisms. Generally, you have the one which is fraud and the other which is coercion/manipulation. So within the fraud bucket, that's where the abuser uses the survivor's identity without their consent or knowledge to obtain money or credit. That's that credit-related transaction. And so this is generally what people think of as identity theft. Like that piece of identity theft is, oh, you don't know about it, you didn't have, any involvement with the transaction, so I took out a bunch of credit cards in your name, or I signed a loan and forged it in your name, things like that. That would be the fraud piece. On the other hand, or the other bucket, you have coercion and manipulation. This is just the coercion piece of the coerced debt, which is where the survivor does whatever the abuser is asking him or her to do, because of the coercive control, right? There's this threat of harm that will happen if the survivor says no. So they use demands and threats. They deliberately manipulate, so they withhold information, or they, many times in my clients' cases, they just said, sign this, do what I tell you to do, don't question me. And especially in many cases where the survivor is limited English proficient, doesn't speak English, doesn't read or write in English, and just is doing whatever the abuser tells them to do. This is that coercive piece. Generally, we see that within these relationships, there are often times where there are some accounts that are from that fraud piece, the ID theft, no knowledge or permission, consent. And then on the other side, there is coerced accounts where they knew about it, they signed to it, they took it out, but it was because of this pattern of coercive control, the threat of harm, either physical harm to themselves, their children, their pets, and it could be, physical harm as well as psychological, emotional, other types of harm that they were afraid to say no to. Now, how does a survivor actually learn about coerced debt? There's many ways that survivors approach us and come to us, and sometimes they don't even know, exactly that it is coerced debt. They will not use that terminology. They don't know that terminology. So generally, it comes out in different ways that we'll explore in the next slides, but can be through them themselves reviewing a credit report, or getting denied credit for something and realizing it's because they have bad credit. Then they pull their credit report, or they're told to, look at their credit. Or it may be in the process of a divorce proceeding where their attorney has them pull their credit report to divide the marital assets, and then they learn of these accounts they didn't know about. It can also happen through correspondence from a creditor or debt collector. That can be a phone call. That can be letters. So it can even be a suit where they get served with notice of a lawsuit for a debt. I've had clients come in with all of those things, and they would never have said it was coerced debt. It wasn't until I started asking them questions about the debt itself that then we realized that this was something that either they had not consented to at all, didn't know about, or they were forced to do it. They can also find out from an abuser confession, from being contacted by a police investigation, or something else where they find out that they're being garnished for a debt they didn't know about. So I had this client happen with clients as well, that they defaulted on a lawsuit. They didn't know what the lawsuit was about, didn't think it pertained to them. I even had one client whose abuser said, yeah, just sign this, and it was an answer to a lawsuit saying that she agreed she was liable for this debt. Again, she didn't read English, didn't write English, just did what the abuser told her, and then found out that we're garnishing her bank account afterwards. So Texas identity theft law encompasses both pieces of coerced debt. It encompasses that traditional fraud bucket as well as the coerced bucket. This was not always the case. This became the case in 2019, and I'll go through some of those laws in a second. But it's because of the way that identity theft is defined in our law. It encompasses this idea of consent and effective consent. And if there is an effective consent, which I'll go through in a couple of slides, is not present if somebody gives their quote unquote consent because of force or threat or of harm. And so now it encompasses both that coerced piece as well as the fraud piece. So as of 2019, the Texas Penal Code, and you see here section 32.51B, changed the definition to include effective consent. So saying that identity theft, was using someone's personal identifying information without their consent or effective consent in order to obtain some kind of benefit and to harm the other person. That's our penal code definition of identity theft. And then there's also what you guys are working on in this program, in this pilot, is obtaining a 521 orders. What we call 521 orders is through the Texas Business and Commerce Code. That's our civil code on identity theft. And there, the definition changed in 2021. Now, here's how it's defined in the penal code. As I said, they commit an offense if with the intent to defraud another, obtain, possesses, or transfers, or uses identifying information of another person without that other person's consent or effective consent. That underlying phrase, effective consent, again, that was changed in 9/1 of 2019. Effective consent is not or consent is not effective if it's induced by force, threat, or fraud. So again, that coercive control piece over here. Or if it's given by a person who by reason of youth, mental disease, or defect, or intoxication is known by the actor to be unable to make reasonable decisions. I highlight that, that's part of C, because even though this pilot program is focused on domestic violence, I found that coerced debt can also happen in elder abuse or foster youth cases where maybe a biological parent or an adoptive or foster parent also utilizes coercive control and abusive relationship to take out debt. So we see this kind of dynamic happening in other types of abusive relationships. And so that C could be used as well, that reason of youth, mental disease or defect, if it's somebody who has a cognitive disease as they age. And then in the identity theft in the civil code in Texas Business and Commerce Code, Chapter 521, that was updated in September of 2021. And it tracks the penal definition in penal code definition in some ways. But here it says a person may not obtain, possess, transfer, or use the personal identifying information of another without that person's consent or effective consent, and with intent to obtain a good, a service, insurance, extension of credit, or any other thing of value. And again, here, effective consent is defined or saying, it has to be given by someone who's legally authorized to act on behalf of that person, but it's not effective if induced by force, threat, fraud, or coercion, again, that coercive piece, or given by a person who by reason of youth, mental illness, or intellectual disability is known by the actor to be unable to make reasonable decisions. I wanted to stress that these two laws were passed in 2019 and 2021 because they're going to be really important later on when determining what steps to take about a debt that was coerced. If it was obtained before 2019, you might be limited in some of your options on disputing it. If it was obtained after 2019, but before 2021, you may have certain remedies because of the penal code definition that you may not have because it's not in the civil code. And then, if it was after 2021, you're going to have all kinds of remedies available. And I know Brittany will be going through the Chapter 521 in more depth and what you can do with that. But I want to stress those because of how you can use those pieces in disputing coerced debt under federal law, not just Texas state law, but federal law. And there was another, because of that, there's another option that may be available to a survivor if the debt was obtained before 2019, when that definition changed. If that debt was obtained through credit card or debit card abuse, they may have the ability to still dispute it under, an identity theft report, which we'll get into later, because they can get a police report based on credit card or debit card abuse. And here it tracks the definition of identity theft, but it is specific to if a credit card was used or a debit card was used. So you see here, effective consent is also part of that definition. And you see that it says it has to use a credit or a debit card with the intent to obtain a benefit fraudulently, with knowledge that it was used without the effective consent of the cardholder. So now we're going to talk through how to screen. Now that we understand what coerced debt is, that it's a type of economic abuse that occurs within domestic violence, either through fraud or coercion, to take out credit-related debt. Then now we're going to see, okay, we're going to go through finding out how you can actually discover if a survivor who is seeking your help has coerced debt. Now, just so you know, we will be having a separate recording that goes through sample credit reports and what is on each report and how you can look at each account and information on there to ask questions to survivors. So that will be a separate recording, but there's questions here that we want to make available to you to ask about. So the second piece here, the second piece here on credit reports and review accounts, that will be in a separate recording, but we'll talk through the initial interview and how to discuss other debt and safety plan. So, there is also a coerced debt assessment tool. You see here that it was developed by Professor Angie Litwin, who's at the University of Texas School of Law, along with Adrian Adams and Angie Kennedy, who are both at Michigan State University. And we have that available as our resources. It goes through sample questions as well as going through the credit reports and what they look like in much more depth. So if that's something that is helpful to you, we have that resource available as well. So we're going to walk through this scenario where Maria calls you for help. She says she's getting, or she approaches you for help after she's been referred to you by the pilot program. She says she's getting collection calls for a cell phone purchase and a cell phone account she does not recognize. This is very common that we'd have clients who come in saying, this is what I need help on, just this one issue. I don't know what's happening. I'm getting these collection calls, or they may have a letter, and I don't recognize this. I didn't purchase a cell phone. I don't have a cell phone account, and they may not give you any more information. And you have to dig deeper to get more information. So just as like background that you don't know because she doesn't tell you, but that you may discover through further questions, is that James and Maria were dating. And without her knowledge, James got a new cell phone and started cell phone service for himself using her name because she had good credit. And after Maria left James, she started getting these collection of calls. And this account may or may not appear on credit reports. Generally, utility accounts or cell phone accounts don't appear until they're in collections. So it's the same for like if you have AT&T or if you have Spectrum for internet. Those won't, when you're current, those generally won't appear on your traditional credit reports until they've been sent to collections, and then that collection agency, that debt collector will report it. So, if one question is if you pull that credit report and it's not on there, is that where your inquiry stops? The answer is no. You want to ask, go through each account and more information to find out if there are other debts that she didn't know about as well that may be coerced. So how do you get a free credit report? This is the first step in doing a screening, is you want to make sure to get a holistic picture of the survivor's, credit or financial information that would appear on these big three, which are the nationwide consumer reporting agencies, Equifax, Experian, and TransUnion. And in order to get that credit report, you have to go to annualcreditreport.com. There is a way to request them over the phone. You can also do it in writing, but annualcreditreport.com is the quickest, easiest way to get it instantaneously, download into a PDF version, and it's free. It used to be that this consumer was only able to obtain a free report once per year, with some exceptions if they were identity theft victims, for example. However, after the pandemic, they have extended this to getting a free report once every week. So you can go to annualcreditreport.com and you can obtain those for the survivor if they have not obtained it themselves. Or if they have obtained it and it was 30 days ago, you want to get an updated copy to make sure that no new information has been added or changed to get the most accurate picture of what is happening. There's also other types of credit reports that exist. You likely won't be using those during this pilot program, but so there are some specialty consumer reporting agencies for rental housing, and that's called tenant screening. For obtaining a job, that's employment screening, and for opening a bank account, that's check and bank account screening. There's two links here. The CFPB keeps a list of all the consumer reporting agencies that they regulate, including these specialty reporting agencies, as well as information on how to obtain a free report from them if a consumer anticipates that they're going to want to apply for housing or for a job or get a bank account. So one of the challenges with accessing credit reports from annualcreditreport.com for the big three is that there may be instances where the survivor is unable to get the information online. That may result for a couple of reasons. One is, recently within the last couple of years, the way to obtain those reports has changed, where you can enter a phone, you first enter in your date of birth, your social security number, your address, and then after that, they'll ask for either an email or phone number to send you a one-time passcode. And then after that, you'll get access to that report. However, one of those still also asks security questions after that. So you would enter all that information, they'll send you a one-time passcode, and then they'll ask you questions about information that would be on your credit report. Like in 2022, you took out a car loan with, how much is the amount per month? Or you took out a credit card with X person, who is that creditor? And, and they'll give you a date, and then they'll give you their multiple choice options. And so if the survivor is a victim of identity theft, they would not know any of the answers to those questions because they would not have obtained it. And as a result, they may answer those questions wrong and not be able to obtain those reports. The same will happen if the address is older than 2 years. The address that they currently reside at is not an address that they've resided at for more than 2 years. So if that's the case, they have to enter multiple addresses, all of the ones they lived at within the last 2 years. And that, of course, could be a challenge if the survivor has fled the abusive relationship and may have been in a shelter or maybe using a different address of excuse me, of a friend, and they do not have that on the credit report. They may not line up. And so that can also be a challenge for verifying the identity of the survivor and being able to then get a copy of the reports. So as you see here, I mentioned Experian uses the multi-factor authentication as well as the security questions, and TransUnion and Equifax only use the MFA with that one-time passcode. But those are the challenges. And then if that happens, then you have to request them by mail. And one of the challenges with requesting by mail is first you have to send a form that has a copy of the survivor's an ID, an official ID. So if the survivor doesn't have their records because they fled the abusive relationship and all of the records are in that home, they wouldn't have a proof of ID to show. They have to also do that address. They also sometimes have to have proof of that address. Not sometimes, they do have to have proof of that address. So if their driver's license has a different address than where they currently reside, they would need to provide a utility statement, a bill, something that has that address on there. So again, if they're on the shelter, it may not have that address on there. If they choose to use a PO box, then that is fine and that would work. But any address that the survivor may want to keep confidential will end up popping up on the credit report. It will become part of that credit file and that record for that survivor that the consumer reporting agency uses to tag with their identity. So if it appears on a report and the abuser is able to get a copy of the report because they have all of that information, then they would be able to see that address, and her physical safety might be compromised. So that's something that they need to know and be aware of. They can use a confidential address if that is part of like the Attorney General's confidentiality program, but just to know that these are some problems with obtaining credit reports for survivors. So the type of information on a Big 3 credit report, and again, we'll have a separate training that walks through this recording that walks through actually looking at that report. But for purposes of this training, this is the information that you should know. There's a file number and a date of report for each of those reports. And that's because the consumer reporting agencies need to keep track of that information. And when you request that information, you'll want to allude to this is what you produced, right? This is a file number. This was the date of the report. So they can look at the records and make sure that whatever you're disputing matches up with what they're seeing. It'll have personal identifying information like their name, social security number, date of birth, addresses, phone numbers, and even employment. It'll have inquiries. Now, inquiries, there's two different types, hard and soft. And hard is, or what sometimes are called regular inquiries. Those do impact a survivor because they can impact a credit score. So if you have a lot of the hard inquiries are where a survivor actually applies for credit. So if I'm applying for an auto loan and that car dealer is trying to see if they can get me a loan from multiple different creditors. So, from Chase, from Wells Fargo, from Bank of America, then all three of them would appear as an inquiry, a hard inquiry on my credit report. And that would ding my my credit score by some points, depending on how many inquiries I have, were they all at one period of time, were they spread out? And so those are the hard inquiries that really matter because they do impact your score. Then you have soft inquiries, and there's two types. There's account review and there's promotional. So account review would be if I have three different credit cards. I have one with Capital One, I have one with Chase, I have one with Wells Fargo. They have access to my report monthly or however often they want to pull my report to see if I'm making payments on time. So that's an inquiry because they're requesting access to my report. And they can do that through an account review. And then promotional are those who maybe have limited access to my report to see if they want to send me offers of credit. Like, hey, you could qualify for this new MasterCard account or this new credit card or whatever it is. And the reason that these are important for you to know about is the inquiries reflect who has looked at the consumer's report, who has had access to it. And if there's coerced debt on there or identity theft accounts on there, then those people should not have had access. Those users should not have had access to the survivor's credit report. And you want to dispute them so that they no longer have access or that it is removed, especially if it's the hard inquiry that's impacting the survivor's credit score. You want them removed because they shouldn't be on there, and your consumer should not be impacted by it. And if it's soft inquiries like an account review, that's for an account that the survivor never took out. They shouldn't have access to the report either. Then there's also on the report, they generally say they have account histories. They'll have them sometimes in categories of accounts in good standing, that are satisfactory, that were never late, always on time, or paid off, but never late. And then you have adverse accounts. And those are any accounts that have ever been more than 30 days late on a payment. So even if the survivor became current later on and there's a zero balance, if they were ever 30 days late, it will be counted as an adverse account. And those, of course, impact credit scores as well. Then there's other sections for collections. So that can include, this example that we gave with Maria that had the cell phone account that went to collections. That's where that account would appear. Generally wouldn't appear under any of the other accounts, like accounts of good standing or adverse accounts, because the original creditor, which is the furnisher, whoever's providing that information to the credit reporting agencies, would not have provided, AT&T wouldn't have provided it. But, Portfolio Recovery Associates, which is a debt collector, could be reporting that debt to the credit reporting agencies. So it would be there in the collections piece. And then there's also a section for public records. So that can include any judgments, any evictions, any bankruptcies. And there are some change in the law here that makes public records no longer really available to be put onto credit reports because of the lack of information that was put on there. So a lot of times the judgments wouldn't have the social security number or date of birth to really verify that it belonged to this consumer. So they don't always put that information on there, but it's still good to know if there's anything on there that may be impacting the survivor. So once you pull the credit report and you look at it, then you want to review all of that information with the survivor, with the client. So you want to go through, and again, in the separate training, we'll go through what the reports look like. Some of them have the personal identifying information at the beginning of the report. So you'd want to go through that first and say, hey, are all of these names yours? Are all these phone numbers yours? Are all these addresses yours? And the reason that matters is because if an abuser took out that debt, they may have put on different numbers and associated with them and not the survivor, different addresses, which would then give them access to information the creditors would all send them information that the survivor wouldn't get. And also, you don't want that associated or tied to your survivor, because then other accounts and other information could be linked with them. So you'd want to dispute that. So you'd want to ask them, like, do you recognize this number? Do you recognize this address? Is it yours? And then the same with accounts. And you want to ask them, like, do you recognize this account? If they say no, then it's potentially could be fraudulent. You want to dive deeper and ask more questions. If they say, yes, I do, you still want to ask more questions, because it could be coerced. One is the fraud piece, the ID theft that everybody thinks of. And the other one is the ID theft coerced piece that most people don't think of. So you want to ask, how, how is this account opened? Did you open it yourself? Did someone go with you? Was someone, were you in a relationship with that person? Did you feel like you had to say yes? Some of these questions. And it may also be the case, and this is a piece that I didn't discuss before, but it may be the case that there's still coerced debt to an account that was the client's before she was in an abusive relationship. So, for example, the client may have had a credit card account with Bank of America, and never added the abuser as an authorized user, and yet he got access to that credit card and made charges on it. So that's that question here. Has anyone ever used this account without you knowing? So if you see charges there, like, that shouldn't be on there. I never used it for $2,000. I'd pay it right away. That would indicate possible fraud as well. So again, coercion, this piece of you, they knew about it, but they signed on to it, or they used it, or maybe they didn't use it at all, just they were involved in the opening. These are some of the questions that you want to dig deeper and ask. Again, can you talk about how the account was opened? Did anyone ever pressure you to use them, to use or let them to use this account, or to open it when you didn't want to? Did anyone have any influence on your decision to open this account? What do you think would happen if you said no? So a lot of these are open-ended questions, not yes or no questions, so that you can find out more and get more information. So as mentioned before, there can be coerced debt that does not appear on a credit report. Like I said, that's usually utility and telecom debt that don't appear until they're in collections. The same could be true of payday loans or title loans. Sometimes these do appear on credit reports. So I had a client once who had like 12 payday loan accounts. There was like Western Finance and Opportune, those appeared. And then I've had clients who payday loans or title loans do not appear at all on the credit report. So you'd want to ask about those. Ask them generally if they owe money to any other people or places. Medical debt is one of these others that may or may not appear on a report. There's some new rules regarding medical debt that may be coming out pretty soon. But if sometimes in the course of an abusive relationship, the survivor may have had to seek medical help for some of the violence. So you can ask about that, and feel free to check back in with TAP if that's the case. There's some other protections that may be available to the survivor. But just talk to them about the debt in general. And then if they disclose more debt, go through the same screening questions with them. There's other, I have here in the slides more examples. Also in that tool that I mentioned earlier, there's a lot of other questions as well. But here are some examples, like, has anyone impacted your credit or debt? A really, really good one. The second one here is a really good one that I start off with all the time, even before going through credit reports. Tell me about your household's financial situation. Who handles the money? Do you talk about the finances? If they just left that abusive relationship, what was it like when you guys lived together? Did they allow you to make decisions? Did they do that? Did they allow you to have access to the mail or not? Do you keep your address confidential? This fourth one is also good. Has your partner ever had you sign anything you didn't know what it was, or ever threaten you to sign something or take a financial action? So these are all other types of questions. Then there's red flag statements. So these are things that when my clients would make these statements, I knew right away that there was likely some coerced debt happening, or there was something that made me want to ask more questions. So one of these is, as I mentioned before, is my ex handled all the mail, or I didn't have access to the mail at all. That's, red flag of they're hiding something. They don't want them to know. There's likely going to be some financial abuse here. Or if they say, you know what, I just don't want my ex to know where I live now. That's likely that there was some abuse in that relationship, because they're scared. There's concern there. I had a car loan. Yeah, I co-signed on one, but I actually don't even know how to drive. I don't have a license. So that's likely some red flag of like coercion there. I can't access my bank statements or, any financial documents. I don't know the password. I am, never had access to that. It's very similar to not having access to the mail, like preventing someone from having access to their financial information. Or I did this, I opened this account because they asked me to. Obviously here, they're not saying there was any abuse. They're not saying there was any fear, but it's a red flag of, I need to dig deeper and ask them more questions about this. Or, if you're going through the credit report and they're like, there, it says like authorized or joint or whatever, and it has the abuser on that. And they say, I guess they added themselves. Like, I didn't know they were on that account. So again, digging deeper and asking questions there. And you see here's the next slide. It has some, if they do say those red flag statements, how you dig deeper, what questions do you ask to find out, was that your decision or not? Were you comfortable, with that? Do you think your ex might hurt you if they find out where you lived? Or why did it end up in your name? Who made the payments? Things like that. Another really important part of representing survivors that have coerced debt is to help them stop future coerced debt, right? So they come to you at the point in time that they do. You can't control what happened in the past, but help them prevent future coerced debt, future economic abuse. One of these really, really important tools is a security freeze, which we'll talk about in the next section. But another is simply helping them, what we call safety plan, which is helping them inform them about thinking through their accounts that may have financial information that may have been compromised. It's very similar to what you would advise someone who is the victim of a security breach or a data breach to do. Changing passwords and PINs on all of their accounts. So checking and savings account, it may even be a best practice to close that account and open a new one that has a new account number, that has, new instruments, devices like a debit card or credit card sent to them, so that the abuser who had access to all of that won't even know it. And to close those old accounts. Same with credit card accounts, online banking access. So not just the checking and savings, but even, like PayPal, Venmo, Cash App, things like that. Other online accounts, so utilities, cable, Netflix, Hulu, whatever. Shopping tools, so Amazon, Google, Apple. Communication tools, Facebook, WhatsApp, Instagram, email, etc., and cloud storage. So changing all of that information. Another part of that is just how the abuser may continue to try to find out information about the survivor, to continue to either harass them or to use their information to be able to take out more debt. And so some of these recommendations are turning phone settings of data tracking, location tracking, geolocation tags, all of this off. Consider using VPNs. And then, of course, taking care of online browsing history and personal information online, about their location and where they may be. So that's all screening. And now that you've screened that, you've walked through the survivor, and we have some resources on a document that can help you fill out that information, where you have the drop down menu of the account number or the named phone number information that's a result of either fraud or coercion, identity theft, and then who the creditor is or the furnisher may be, and kind of the next steps to take. So you have all of that information, and now you have to figure out, okay, well, what do we do from here? How do we dispute this? How do we try to address this? And so that's what we're going to cover in this next section. So first of all, you want to identify, again, all the information that is coerced debt and which reporting agency it's being, referred to, right? So is it on Experian and Equifax and TransUnion? Sometimes there's an account that is on two of them and not on one of them. It may be on all of them. So you want to keep track of that as well, who it's being reported to. Is somebody collecting on the debt, whether it's the original creditor, that Wells Fargo, Chase, et cetera, or is it in the hands of a debt collector, Portfolio Recovery Associates, LVMV Funding, whoever it may be. And then after you gather all of that information, then you want to discuss with the client what they would like to have happen. And that is because, our approach is always to be trauma-informed, survivor-centered, meaning they drive this process. They may decide, after you discuss their options with them, their legal options, you could do this or you could do that. They may say, wow, that sounds like a lot. I don't think I can do that right now, and that's okay. Or they may say, yes, I do want to, pursue this remedy, but not that remedy. I want to dispute it, but I'm not sure if I want to go to court. Or yes, I want to go to court and I want to do all of these different things. So you want to discuss that with them. And then, as a lawyer, it is obviously our job. We say this often, that the survivor is the expert in their life, but we're the expert in the law. So we tell them, here are your strategy, here's your remedies and here's your strategies and here's my advice. And, as counsel, I recommend you do X, Y, and Z, and then you allow them to decide. So it's important to always ask them, what their goals are. Is it just that they don't want more debt, right? And then we'll walk through that, the security freeze, things like that. Is it that they only want to deal with the credit reporting? They don't actually care about liability. They don't care about collecting on the debt. They only want it to come off their credit report. Or is it that they just don't want to hear about this anymore? They don't want anybody contacting them about the debt. They don't want to, they want nothing to do with this. Or do they also want to fight the debt itself? Like, they don't want to have to pay. They want it not just removed from their credit report, but nobody can ever come after them because it's not theirs. So these are things that you want to talk to them and ask them about what their goals are. Again, it's going to depend on the facts of the case and the type of debt and who the creditor is, which we'll get through when we talk about legal remedies. So each course of action will be different. And it's important to also know that you may not be able to assist this consumer in the way that they want. So it's possible that you've helped them dispute, you've helped them with the 521, and it's still appearing on the credit report, or they're still getting collections calls or notices about this. So you may need to refer the survivor to consumer attorney for possible litigation. And again, you'd come back to TAP for that if you have those kinds of challenges with your case. So now, disputing the coerced debt. So we've talked through here, there's these kind of, just in general, credit reports and what appears on credit reports and some of the players. But there's two pieces here of the negative impacts of coerced debt that we'll kind of deal with separately. So one, as I mentioned before, is just the negative reporting. So that, again, it's appearing on the credit reports, and the fact that it appears on the credit reports harms them in a couple of ways. One, it lowers their credit score, or it prevents them from being, and as a result, it prevents them from being able to get that housing, that credit, that job that they may need. And so it's just the reporting itself has negative impacts. That's different from the debt collection piece, which is on the liability itself. So either they're getting letters or calls or a lawsuit about this debt saying, you have to pay this, you have to pay this, you have to pay this. And so that is different then the reporting of it, this is the liability of it, the collecting of it. So it may not impact, just the debt collection piece won't impact their ability to get future credit necessarily if it's not on their credit report, but it's somebody seeking collection and may be taking legal action to collect on that debt. So I've mentioned all of that already. It's in this slide. And so we will get through the law that I'm going to cover on credit reporting is the Fair Credit Reporting Act. And so we'll take some time to go through that and the remedies that are available to coerce debt victims under the Fair Credit Reporting Act. And then with debt collection, that can be trickier depending on the type of debt that it is. So I'm going to just focus on credit card debt and talk through the remedies for credit card debt. And the reason I'm going to focus on that is because the vast majority of coerced debt ends up being credit card debt. That's the first. The second ends up being auto loans. And then after that, other types of debt, but predominantly those are the two big types of credit-related transactions associated with coerced debt. So we'll talk through the federal law that governs credit cards and disputing credit cards, which is the Truth in Lending Act, and then also talk about debt collection statutes, which is more general to all types of debt and debt collection, consumer debt. So there's a Fair Debt Collection Practices Act, which is the federal law, and then we have a Texas law on debt collection that I'll talk through. So the key players who you're going to be disputing with is either the consumer reporting agencies or the furnishers, which I'll talk through who those are. Generally, those are the people that are supplying the information to the credit reporting agencies on that particular debt. And those furnishers are generally either creditors or the banks or debt collectors. And then, you want to deal with them kind of separately, right? So you're going to deal with the credit reporting piece, and then you're going to deal with the debt collection piece. So these are you see this alphabet soup here, and these, I'll go through each of them individually. But so you can refer back to these. These are the types of remedies that are available to identity theft victims and as a result, coerced debt victims. So the Fair Credit Reporting Act, the Truth in Lending Act, the Fair Debt Collection Practices Act, the Electronic Funds Transfer Act, and then our state law, which is Chapter 521, Texas Business and Commerce Code. So disputing coerced debt on a credit report. All of this will be governed by the FCRA or FCRA. So if you hear me say FCRA, Fair Credit Reporting Act, that's what I'm talking about. It is all found in 15 USC 1681, and it is broadly defined as far as what a consumer report is and what a consumer reporting agency is. But a consumer report is broadly defined to be, any information that relates to a consumer's creditworthiness, character, general reputation. And so it's pretty broad. But in order for it to be a consumer report, it has to be something that is compiled and sold using interstate commerce by a consumer reporting agency. And so a consumer reporting agency, again, is also kind of broadly defined. But as I had mentioned earlier, there's the list of the CFPB of consumer reporting agencies that it regulates. And so if you're concerned whether or not it's a CRA, don't be, if it's Experian, TransUnion, or Equifax, then you don't have to be worried because those are consumer reporting agencies, they're CRAs. And so this law mandates what can be included in the consumer report. So, what kinds of accounts, how long that information can be on a credit report. So, if it's a negative account, it has to fall off after 7.5 years. So it talks about that. Who can access the report? These are the users, like who can look at my report, who is allowed to look at it. When the consumer has a right to get a free report, and then their right to dispute any information that's inaccurate to have it corrected. So the consumer reporting agency has this basic duty to make sure that it has policies and procedures in place to assure maximum possible accuracy of the information that it compiles for an individual consumer. So that means, they can't just put anybody's information on my report. They have to have policies in place to make sure, reasonable procedures to make sure that they all actually do pertain to me. So they should match my date of birth, my social, my address, all of that information to verify that that account really is me and belongs to me and should be on my report. Who can access reports? Consumers have a right to access this report. Third parties or users can access them, but only if they have a permissible purpose. That's found in 15 U.S.C. 1681b. Some examples of permissible purpose are on the next slide, but generally, I talked about those promotional or I'm sorry, account review inquiries. So they have the ability to access my report. Anyone I give permission. So if I apply for credit and check, giving them permission to pull my report, they would have access to it. And the access to that report is called an inquiry, a pull, or access. We already talked about the different types of inquiries as well. So these are more examples of permissible purposes, and you see them here. So now all of that is kind of background on the FCRA, what it does, what it regulates. It's a really broad, but I'm going to go through now specifically the remedies that are and the rights that the FCRA provides for ID theft victims. So the first is the block, and I'll be spending some time talking about that. Then there's security freeze, which I'll spend some time talking about that. And then there's fraud alerts. There's an initial and extended. I won't be spending a ton of time on these because I frankly find these not helpful at all, but I will at least tell you what they are. Most of these protections, the block, the security freeze, and the fraud alert, most of them require an identity theft report, which I'll define in a couple of slides. But if you don't have an identity theft report, you can still request a freeze, and you can also dispute the information and request a deletion, which I'll get through later as well. So there's some things that a coerced debt survivor can do, even if they don't have an identity theft report. So what is an actual identity theft report? It is defined here under 1681A Q4, and generally it is a report that is filed with law enforcement or whoever the Bureau, being the CFPB, designates. So generally that that is law enforcement is police report. So your local law enforcement, whether it's your county, your sheriff, your police department of a city. It can also be the Federal Trade Commissions. They have an identity theft report at idtheft.gov that you can file, and they're a law enforcement agency, so that would qualify. If the theft, identity theft was done through the mail, then the U.S. Postal Inspection Service report would qualify. And then FBI, if it was done through the internet, you can do an FBI crime report. That's ic3.gov. And then now these other documentations aren't generally an identity theft report, but they may be helpful to prove that the person was an ID theft victim. And that would be a protection order, so PO, judgment of divorce, or even a 521 ID theft order, which is what we are trying to achieve through this pro bono program. So as I mentioned before, the reason I talked about the dates about, if this debt was incurred before 2019 or after 2019, but before 2021 or after 2021, is because what you may be able to obtain. So if it was done, as you see here in this graph that we'll make available to you, if it fits within this bucket of fraud, right? They never knew about the debt, they didn't consent to it, by signing or anything like that, then they will be able to obtain, any of the, like a police report. You can file a police report for that. You can do for ID theft. You can do an FTC report. And then again, if it's credit card or debit card abuse specifically, then yes, you can get that. If it was through the mail, then you can get that USPIS ID theft report. So again, if it fits within the ID theft traditional bucket that everyone thinks about, you have all of these remedies available. The reason there's a maybe there is because it depends on whether the account was credit or debit or whether it was done through the mail. Now, if the victim had knowledge, but was coerced, So again, within the second bucket of the threat of harm, force, manipulation, if that was prior to 2019, you will not be able to get any of these reports, the FTC ID theft or the police report, because it didn't meet the definition of identity theft at that time. The laws are not retroactive, so it's as of 2019. So no police report, no ID theft report. However, if it was if it was a credit or debit card, it would meet the definition of credit or debit card abuse because of that effective consent was in that definition prior to 2019. So you'd be able to get a police report for that. And then again, it depends on whether or not the USPIS, if the mail was used. If the victim had knowledge but was coerced to take the debt after September 1, 2019, then they can get the FTC report. They can get the police report. And then again, the maybe on the police report for credit or debit card abuse or the USPIS is the same as, the first one. Depends on if it's that type of account and if it was obtained in that method. So identity theft report, again, you need that to get certain relief under the FCRA. And in order to get the identity theft report, you have to be an identity theft victim. And so if it was obtained, from 2019 until today, you can get a police report for it here in Texas, if it was obtained through coercion or fraud. If it was just obtained through coercion, you can also get that report if it was done after 2019. And then you can use that to dispute the debt, to request the block, to do all of the things that we're going to talk about now. So a block is essentially a tool that the consumer reporting agencies have to prevent any information that resulted from identity theft from appearing on a consumer report, so on the survivor's credit report. So let's say, for example, that I have 10 accounts that are all the result of identity theft, and they're all on my credit report. I can say, hey, Equifax, here's a copy of my police report showing that I'm a victim of identity theft. Here are all the 10 accounts that were from identity theft. I am requesting you to block that information from appearing on my report. And so they have 4 days from the receipt of notice to make sure, to basically check that my request has all the things that it needs, which is right here on this slide. And then they have to block that information. There's only a couple of reasons they can refuse that block, which are also at the bottom. And so if they do that, then the next time I get my credit report, whether it's in that week or 30 days or whatever, those 10 accounts cannot be on my report because they've been blocked from appearing on my report. Now, technically, they may still be in my file. There's a distinction between a credit file and a credit report. The credit file is all of my information for my entire, for as long as they've had information about me. So if they started gathering information about me when I started getting accounts at 18, then they will have all that information in my file, but it may not all appear on my report. And there's, as I mentioned before, there may be accounts that are too old to appear on there, and so it can't be on my report, but it's still in my file. Or even things like this where I request them to be blocked, so they can't be on my report, but they'd still be in my file. Later on, I'll talk about the other, mechanism to dispute and request that they be deleted. And if you do that, then they do have to be removed from both your report and your file, but that's just a separate provision. That takes longer. It's, it's 30 days to investigate. They have to let the furnisher, which is either the creditor or bank, know. They have to investigate as well. And so the block is quicker. It is, within 5 days, 4 business days, but it's 5 days. And so that is generally kind of the better option if time is of the essence for the survivor. And you can always do both. You can request the block and the deletion. Again, one would come quicker and the other one would take more time to get the final resolution. But you can do both. And so for a request to block, it has to have certain information in it. It has to have proof of your identity. It has to have a copy of an identity theft report. So again, that police report, the FTC identity theft report. And it has to identify the information that you're requesting to get blocked. So whether that's phone numbers, inquiries, addresses, names, accounts, or even just charges on an account. So the whole account is not fraudulent, but there are some charges that are. And then a statement by the consumer that the information is not related to the consumer. So that's, that would be checked. If you say, I'm a victim of identity theft, I didn't, take out any of this, I didn't take out these accounts, I didn't use this account, or, anything like that. This is not related to me. It shouldn't be on my report. It's not me. Now, they can only refuse to block that information if the request was made in error, or it was based on a material misrepresentation by the consumer, so the consumer lied, or if the consumer was the recipient of funds, goods, or services of the blocked transaction. So that's kind of tricky, because if some of this was based on, for example, a coerced auto loan that you're requesting to be blocked, but the consumer, the survivor, actually has possession of the auto and is driving it, then the CRA can refuse to block it because they did receive those goods. So it's the same if it was like a credit card and it was used to purchase a TV and the consumer has possession of the TV. So again, this is more, the list of information that you can put in the letter requesting the block is, accounts, the charges, the addresses. I already stated this before, but it's written here, so you can check it off when you are looking through your, what to put in the letter, what to include. And then most importantly, what I haven't yet covered is the very last thing on this slide, a request to receive an updated copy of the report. So once you send in the letter requesting the block, and they have that 4 business days to put the block on, they also have to notify the consumer afterwards that they have blocked it or that they refuse to block it. And so at that point, if you've requested a copy of an updated report, they will also send you a copy of that. And you also, in addition to what you include in the notice, in the actual letter, you have to include other documents. So these are the documents you include with the letter. That photo ID that's state issued, or that proves their identity, and with their current address, if it's not their current address, and any other document showing a current address, that ID theft report and the police report. It's sufficient, it should be sufficient to just have one. In practice, I have found that sometimes you need both. So I put both the police report and the FTC identity theft report. Include a copy of the credit report with the highlighted or circled disputed and inaccurate information. Even though you already listed it in the letter, I don't know why, but they just don't have the best procedures, which is why they often get sued. And so I try to make it as foolproof as possible. Like, I put this in my letter, but also I included it in the report, and here's all the information. You want to send it by certified mail, return receipt requested. And that is because you want proof that they obtained it, that they received it. And also, so you know the date of when they received it, so you can count how many days from when they received it to them blocking that information and responding to the survivor. So that was the block. I will go through security freeze. I'm going to actually skip to that slide, and then I'll come back to the dispute process. So a security freeze is free. It doesn't cost anything, and you don't have to submit an identity theft report. That law was recently changed. It used to be that either you had to submit a police report or pay a certain amount, but now that changed after there was a huge Equifax breach. So now anyone can request this. You can do it over the phone, or you can do it in writing. My recommendation is, if you need it quick, the survivor needs it quick, do it over the phone and then follow up in writing with either the request to block or the dispute letter, disputing it, or, if you're doing all of the things, and put it in that letter. What does it do? What does it actually do? So it is exactly what it says. It freezes. It prevents anybody from getting access to that survivor's credit report. And why this is really crucial and important is because if your client does not need to take out any new credit, this will prevent any new credit from being obtained without them knowing. So if the abuser is trying to take out new credit, it will stop that, because that, let's say he's applying for a credit card or he's applying for an auto loan, and they try to pull the report, there's going to be a freeze. They can't access it. And it cannot be lifted or unless the survivor calls and requests the lift, and they have to provide a PIN, which is given to them after they get the freeze. That's the only way to lift it. It does not prevent the survivor themselves from being able to access the report. So, and it does not prevent anybody who already has existing accounts, so those like account review inquiries that I mentioned before, they can still look at it. Certain government entities, so child support, so they can use that. And also, if you're applying for housing or employment, they'd still be able to obtain that information. But as a best practice, I always tell the survivor, if you know you're going to either apply for a job or for housing, or even if you're going to apply for credit, go ahead and lift that freeze just for that amount of time. So you can lift the freeze for, like 30 days or 3 days, or you can even lift it for just a particular creditor. So if you know you're going to apply for, credit with Chase, you can just lift it to Chase. So these are the practice tips. Again, you can also request it by phone, mail, or website. So these are the websites. I generally try to steer people away from the website because of arbitration clauses that I don't, want them to be bound by if something goes wrong. So I think by mail or by phone is the best way. If they do it by phone or, again, online, the freeze has to be placed 1 business day. By mail, then 3 business days. Once they obtain confirmation of the freeze, which they have to get afterwards, it will have that information in that letter on how to remove it or to lift it, the PIN that they need, and all of that has to be given within 5 business days after they receive the request to freeze. So I mentioned this already. It can be removed permanently or temporarily. It's called lifting or thawing. And so here's kind of how you do it. You can do it the same way by phone, it's the quickest. And so once they have it by their PIN and that letter, then they just pick up the phone, and it has to be done within an hour. And then if it's done by mail through a letter, then 3 business days. So I am now going to go back to the disputing process before talking about the fraud alerts. So we talked about the block. The block is only for ID theft. The freeze is for anybody. The fraud alerts are only for ID theft, but again, I'll cover those later because I don't think they're that important. But then the dispute process is for everybody. So you don't have to be a victim of identity theft, but certainly if you are a victim of identity theft, you can still use this process. So as I mentioned before, this is where it takes a little bit longer time. It takes 30 days, and they do what's called a reinvestigation. Even though it's the first time they're investigating it, it's still called reinvestigation. So you send this dispute to the CRAs. You say, hey, Experian, hey, TransUnion, I am disputing any inaccurate information on my report. So for a coerced debt victim, the reason would be identity theft, right? You're saying this shouldn't be on there because it doesn't belong to me because I'm a victim of identity theft. And you put all of the information, that is as a result of identity theft on there that you're disputing. But if there's other inaccurate information, just so you know that other people can dispute, it's like, hey, this account says that I was late. I was never late on those payments. Or, hey, this account is, showing that it is a joint account, but it's actually just an individual account. Or, hey, this account is 7.5 years old and it should not be on my report anymore. Or, hey, whatever is the inaccuracy, or, hey, this shows that I was that I'm, owe $2,000, but I only owe $1,000, whatever it may be, any inaccuracy you can dispute. So what happens here, which is a little different than with the block, here the CRA has to send notice to the furnisher, and the furnisher has to investigate, and then the furnisher tells the CRA what to do. So they'll say, "Yep, this information is accurate. Confirm." So it'll be, the result will be verify. Or they'll say, "Oh, wait, you're right. This information is not right. Update it." So if it was an account that still should be on there, but it was an amount that shouldn't be there, or charges that shouldn't be there, then they'll update it to reflect the accurate information. If the whole thing shouldn't be on there because the whole thing is identity theft, then they will tell the CRA, "Hey, delete this information." So they will tell them verify, update, or delete. That will be the response to the investigation. The CRA technically has discretion to themselves because they're also supposed to do an investigation. So they could very well say, "Yeah, we agree with you. It's identity theft. Let's delete it." But the way that it works, they actually rely or they parrot whatever the furnisher says. So for that reason, I always, the furnisher is supposed to get everything that you send to the consumer reporting agency. Sometimes it doesn't work out as cleanly. So I always best practice send the dispute letter that you're sending to the CRA, Experian, Equifax, TransUnion, also to the debt collector. So you want to, or the creditor, whoever's furnishing that information. So if it's a Chase, you do Chase. If it is LVMV, you do LVMV. Send it to both by certified mail. So once the consumer reporting agency gets that dispute, they will send it out, and then they will wait on the results, and then all of this is supposed to take 30 days, and then they will respond to the survivor with the results. The results have to be in writing, not later than 5 business days after that. They say the reinvestigation was completed. They give you a copy of the revised consumer report if you request it. If not, they'll just give you snapshots of what they did. And then, depending on what the outcomes are, they have to say the consumer has the right to add a statement to their file disputing the accuracy or completeness of the information. So, again, it will either say verify, update, delete, and you'll note that. So what do you actually include in a dispute letter? Similar to the request for block, you include all of the information that you're disputing that's inaccurate, and asking for it to be removed or updated and why. So again, you see here, counts shouldn't be on there because of identity theft. Coerced debt is the term that we're using, but they don't, the consumer reporting agencies don't recognize that. So you'd want to explain that it's identity theft. The charges that the survivor didn't make, that don't belong to them. The addresses, the phone numbers, inquiries that don't belong to survivor, all of those things are what you're going to dispute. So again, you explain why it's inaccurate, and then you ask for a copy of the updated report. And then again, with the letter, similar to the block, you want to include, the report with all of the information that you're disputing, highlighted, circled. You can also, provide a copy of, you don't have to provide an identity theft report like you did with the block, but if you have it, I would include it as well, to show that you are a victim of identity theft, if that's the reason we're disputing it. You can also include other requests, right? You can include, hey, block this. And so if you're going to request a block, you have to include the identity theft report. Block this. I'm also disputing it. And also I want a security freeze or fraud alert if you want them. And then again, best practice, certified mail return receipt requested. So now that I talked about that, now I'll talk about fraud alerts and why I think that they're not very helpful. A short-term fraud alert is free, and you don't actually have to submit an identity theft report. It lasts for a year, and then after that you can renew it every year. But essentially what it does is that it says, for any when a credit report is pulled for a survivor, there's like a little note on there that says, hey, you want to make sure that, the person who is applying is actually the consumer, take reasonable steps to verify their identity. And it says they may contact the survivor if they provide a phone number, but they don't have to. And so it is super wishy-washy. Like there's just like, hey, try to make sure you do this, try to make sure you do that, but there's no, you must do this. And then there's an exception for it as well, which is that it doesn't apply if they're obtaining a new credit card, because it exempts what's called open-end credit. So any credit card, this wouldn't apply. When they pull it up, none of that would show up. Or if it's an existing credit line, and you're asking for an increase or adding an authorized user and asking for a new credit card, this won't show up either. And because a lot of coerced debt happens with with credit cards, then it's essentially pointless at really helping prevent new credit card debt and new coerced debt in that form. So that's why I'm just going to skip through it because I don't think it's that important. The extended fraud alert is a little bit better, but not by much. It is 7 years, and it is, for this one, you do have to submit the identity theft report. The only difference here is that it says that the CRA has to provide the survivor's phone number or reasonable contact method that was designated by the consumer. And the creditors have to contact that person in that contact method. So this can be helpful if the survivor actually says, hey, here's my phone number or email or whatever I want them to contact me at. And then the creditors are supposed to do that. But again, the exception is those credit cards, new credit cards, existing credit card with either an increase or an authorized user. So again, because so much of it is through credit card debt, this really won't prevent that. So don't think it's super helpful, but the information on how to request that is all in here. So again, that was a lot of information. We're just going to review it real quick. So if the survivor is the victim of coerced debt, they can request a block as a victim of identity theft. They can dispute the information. They can request a security freeze or any type of fraud alert in one letter or in separate letters. And again, it will depend on if they are able to get a copy of that police report or identity theft report based on when the coerced debt happened. If it was post 2019, they'll be good. If it was pre 2019, they may not be able to request the block, but they can dispute it and get a security freeze. You want to send these letters by certified mail return receipt requested, and include all of the attachments, the identity theft report, a copy of the report with it circled, a proof of identity, all of those things. And last but not least is the letter should be written in the voice of the survivor. So you're not, you don't write it saying, hi, I'm, Carla Sanchez Adams, I represent Jane Doe, and I am disputing this on her behalf. That won't work. It has to be the survivor who disputes it. And you want it, in their voice. And I have in here, you may need to use a translator certificate. So, I had clients that didn't speak Spanish. That didn't speak English, only spoke Spanish. And so, I would there at the bottom say, I'd write it in their name. And, again, Jane Doe, write it, sign Jane Doe, and then at the bottom put, this document was translated to me. And, we have an example of a translator certificate, write my name, say, they don't read or write English, they speak this language. I would translate it for them into English and have my signature. The return address as well should not be your firm. It should not be your address, but it should be the address of the survivor. They will receive all correspondence. So all of the letters with the results of the investigation or the results of the block, the updated reports, all of that will be received by them. So you will need to tell them to make sure to look out for those letters, those documents, and then to bring them to you or to email them to you or to fax them to you. There are some applications phone applications. One is called Scannable, where you can take pictures of the document. It turns it into a PDF that you can then text or send by text or send by email. And you also want to advise your client that whatever address they receive will the mail at the correspondence at will become a part of their file and appear on their report. So you want to make sure it's a safe address. Always request an updated copy of the report. And then again, if the dispute doesn't work, especially after obtaining a 521, refer the survivor to a consumer attorney, contact TAP again. So again, one more review before we go on to disputing it through debt collection piece is this is the mechanisms, right? We just talked about the negative credit reporting and the options here under the Fair Credit Reporting Act, right? The security or credit freeze, short-term extended fraud alerts, the block and the dispute, all of those things is dealing with the negative credit reporting piece. What we'll go into in the next section is debt collection efforts. So, how to dispute with credit card debt, how to contact debt collectors, the 521s, and then we'll briefly talk about debit and bank accounts and how to dispute money that's been taken through the survivor's bank account under the Electronic Funds Transfer Act. One second. So now we're going to talk about disputing coerced credit card debt with the original creditor. So again, this is if it is still being pursued by the bank that issued the credit card. So it wouldn't be a debt collection notice, a debt collection letter, but it would be a statement that the survivor receives or maybe does not receive. If they didn't take it out, didn't know about it, and they've subsequently moved, they may never have seen a statement or gotten a statement. They may only have discovered about the credit card debt through the credit report. It's also possible to use this remedy that I'm going to discuss for debt that was coerced for an existing credit card account. So if the survivor had a credit card account, with Wells Fargo, and then the abuser used it without her knowledge or permission, then the survivor will be able to dispute those charges as well. So the law that applies to credit cards, the federal law that applies to credit card is the Truth in Lending Act. And then there's a specific provision of the Truth in Lending Act called the Fair Credit Billing Act. And the reason I mention both is because there's two different mechanisms. So, TILA is the broader law, and it doesn't just govern credit cards, it governs other types of credit as well. So like mortgages and auto loans and other types of financing. But it also covers open-end credit, which is what credit card is. So there's TILA, and then there's a general unauthorized use provision of TILA that you can use, or the Fair Credit Billing Act and billing errors, and there's those provisions that you can use. And I'll go through both of them to explain how they're different and how they can be used. The phrase that is used in TILA is not identity theft, but it's unauthorized use. It's either an unauthorized account or unauthorized charges. And I will, again, in the following slides, define what those are under the statute. So it is narrower than the definition of identity theft under Texas. So for some coerced debt survivors that were just coerced into these transactions, they will not be able to use the provisions of TILA to dispute those charges or those accounts. It really will only be for those that were unauthorized. And again, I'll explain what those are in the next slides. The law does require, similar to the FCRA, an investigation and notice of the results. They can't just say, sorry, it's not unauthorized because you were married to this person or you were in a romantic relationship. And I'll explain in some more what the investigation actually requires. So as I mentioned, there's these two parts that can be used. the Fair Credit Billing Act, which is found here in 15 USC 1631 et sec, or the more general provision, which is 1643. So again, the billing error, that's what we call the Fair Credit Billing Act, governs billing errors. So this is, you can dispute credit card unauthorized use under the billing error procedure. There are there are 6 different billing errors that are defined under the statute, but we really will only be focusing on this one, which, as you see here, is a reflection on a statement of an extension of credit which was not made to the obligor, or if made, was not in the amount reflected on such statement. So this is what you would be using, saying, I did not, it was not made by me, right? I did not purchase this, whatever. I did not make these charges. That is what you would be disputing. You can also, a billing error, you can dispute just one charge or several charges or the entire account. But with the billing error procedure, as I'll talk to in the next statement, it is very strict on how you dispute and when you notify of the dispute. So it is very narrow, not just in the definition, but also in its application. And then if you see here, Regulation Z is the regulation that implements the Truth in Lending Act. And so if you see here, the interpretation of Regulation Z, or I'm sorry, the provision of Regulation Z pertinent to B1 that I just mentioned defines it as a reflection on or with a periodic statement of an extension of credit that is not made to the consumer or to a person who has actual, implied, or apparent authority to use a consumer's credit card or open-end credit plan. The reason I mention this and the reason it matters is if this was, it hinges on whether the abuser had actual, implied, or apparent authority. And why I say that is because often you can have an authorized user on a credit account. And so if the abuser was an authorized user, even though she didn't make the purchases and he did, even if she didn't know about it, if he was an authorized user on the account, then she won't be able to use this provision because he was an authorized user and he had authority to use the credit card. So here's the part of the billing error procedure that is pretty strict. You have to send the dispute within 60 days of the first bill or statement that contains the error. So it has to be not just does it have to be within 60 days, but it also has to be in writing. And it also has to be in writing at the billing error dispute address. So it is generally on a statement. On the back of the statement, it'll say for billing errors, and then it'll have an address. And that is the only address you can use. You can't use a general address. You can't do it over the phone. It has to be in writing. It has to be within 60 days of the first statement that has the unauthorized use, and it has to be sent to that address. Once they receive that, they have to acknowledge receipt of the dispute within 30 days. So that's not when their investigation concludes. It's just them saying, hey, I got your dispute. Cool, within 30 days. And then they have up until 90 days to finish the investigation. And then after the investigation, they either remove the charges or conclude it's still owed, and they have to give you the results and all of that. So what do you include in the letter? It doesn't have to be any particular format, doesn't have to have any magic words, but it does have to have enough information for them to be able to actually investigate it. So that includes, the consumer's name and account number. The challenge here, as I mentioned before, is the consumer might have never received a statement. And if they didn't receive a statement, it's kind of hard because it's like within 60 days of the statement. You can still do this and say, I've never received a statement. I found out about this through my credit report. These upon information and belief, here's the account number. Usually on the credit report, it's truncated, so you don't have the full account number. You either have the last 4 or the first 6 or the first 8. You may only have what you have. So as a result, you give your name and social, the survivor's name and social security number, along with whatever account information you may have. And then you have to say why it contains a billing error and the amount of that error. So saying like, I didn't authorize this account at all. I didn't open it at all. It's not mine. The whole, I'm disputing the whole thing, including all of the charges. And then the reasons, right? Saying I'm a victim of identity theft. Here's a copy of my FTC report or my ID theft report, the police report, whatever it may be. They also can and should request copies of whatever evidence the creditor uses to make the decision after the investigation. And the reason that's important is, again, if the survivor never had any statements, never had the account agreement, never had any of that, you want to have that to be able to use if you're going to apply for a 521, because you want to have the full account number. You want to have all of that information. If the survivor is refusing to pay it because it's not theirs, the charges aren't theirs, then the letter should also say that they're withholding that amount. What else do you include with the letter? Again, they're not required to provide an affidavit or police report, but if you have the ID theft report, whether it's the FTC report or the police report or anything else, I would include that. In practice, even when you've complied with all of this, I have often found that they will send a response letter within the 30 days saying, hey, we got your dispute. And also, we want more information. Please fill out this affidavit. Or please fill out this form. And it'll have a bunch of questions. And it's extremely frustrating because all of their questions are contained in your letter or in your police report or in if your FTC identity theft report, like you have all of that, and yet they're still asking you to fill out additional information. Now, whether that's reasonable or not is subject to a finding of fact by a court. And so I would, even though it's frustrating and in theory under the law, you shouldn't have to do that. I would say, please do go ahead and tell the survivor, hey, you may be getting this. Please fill it out. Please send it back. Again, as I sent here, had to be to the correct address, the billing errors address. And so, even if whatever affidavit they get, send it back there, send it by certified mail, return receipt requested, because that starts triggering all of the dates. If they receive it, May 1st, then 30 days from May 1st is when they have to tell you they received it and ask for any additional information. And then 90 days from May 1st is when they have to conclude their investigation. Once the dispute is sent, the survivor can withhold the payments or the amount of dispute, or they can continue to pay it, but tell them that they're going to be seeking a refund without waiving any of their rights. So, it waives some other rights, which I'm not going to get into, but it doesn't waive their billing error rights, like the right to do the dispute. To do the investigation and give them notice of the investigation. They cannot, while the dispute is pending and the investigation is pending, they cannot subsequently impose a finance charge on the disputed amount if it turns out there's no billing error. So they can't penalize them because you're not paying it, you're disputing it, and you're waiting those 90 days. They can't say, well, now you owe it, and now pay us all this interest, right? They can't do that. They can't attempt to collect the amount that's in dispute until the investigation is resolved, but they can reduce the credit limit. So if you have a $5,000 credit limit on the account and you're disputing $2,000 and they're like, well, I'm going to reduce the amount of their credit limit to $3,000 instead. And then if there's any undisputed amount, they can continue to collect on that. There's also some, other provisions about this, about how they're supposed to report it. So they do, on a credit report, it has to be reported as in dispute. They have to notify the consumer reporting agencies of that, and they can't report anything delinquent or negative that's in dispute. So again, if it's like if there's $1,000 worth of charges on the account, $500 are what you're disputing as unauthorized. If the other $500 is delinquent, they can report that amount as delinquent, but not the disputed $500 that they're investigating. So for the most part, I think most of my clients were disputing the entire account, so we didn't have to think through that. But if it's an account that existed and then had some charges to it that were unauthorized, then you'd have to think through some of those pieces. Whenever that happened to my client, it usually was that the account was in, zero balance and then it was used. So again, there wasn't this challenge with what's in dispute, what's not, what's being collected, what's not. But just so you know that that's what the law says. So that's all for the billing error under the Fair Credit Billing Act. But what happens if your client doesn't find out about that within 60 days? Maybe it's a month, I'm sorry, maybe it's 6 months from when the account was opened, or maybe it's 2 years from when the account was opened, and so they didn't know about it at all. Then there's another provision of the Truth in Lending Act that you can use. It's their general provision on unauthorized use. It doesn't have a time limit. It doesn't have to be in writing. It doesn't have to be at a particular address. You can dispute the whole account or just the charges. Even though you can do it over the phone, which is mostly what we did with our clients, is we'd have them dispute it over the phone initially, then we'd follow up in writing by certified mail return receipt requested. And there's no requirement as to where that goes, like what address it goes to, or timing or form. I often would send it to the billing errors address as well as to whatever address was on the website, or maybe even what's on the credit report. I would just send it to as many people as I could, even though that's not a requirement, just to show that she didn't, that the client did in fact dispute it. Because if you're doing it over the phone, sometimes you don't have that proof. And so we would have, send it to multiple locations. Once the notice is given, the liability for the unauthorized use is frozen at the amount of the unauthorized use, or $50, whichever is less. So, and there's certain things they can only do that, impose that $50 if certain things are in place, which, I don't have to get into, but generally it's if they provided a means for use by identifying the consumer, right? Like if the merchant required like a signature that was on the back of the card, or a photo ID, if those things were imposed, then they could hold them liable for the $50, but they can't if it was done online, or in a way that didn't require verification of identity. It's rare. I've never seen in a case of true unauthorized use. I've never had a client where they impose a $50, because if it was identity theft, the whole thing was identity theft. But note that provision is there. So now the definition of an unauthorized use here is a little different. When I talked through the billing error provision definition, it was like the actual implied authority, all of that. This one is and it talked about like any charge that was made. This is a little different. So this says it's the use of a credit card by a person other than the cardholder who does not have actual, implied, or apparent authority, and from which the cardholder received no benefit. So this last bolded phrase, which the cardholder received no benefit, has caused some heartache to some practitioners, because again, if it was the whole, the whole account was open without the survivor's knowledge or permission, but then the abuser used it to purchase household goods that the consumer benefited from, right? So food, gas, TV, couch, clothes, then they wouldn't be able to use this provision. Even if they didn't want it, they wouldn't have wanted it, they wouldn't have, wanted to pay for it. If they still benefited from it, they can't use this provision. Again, there's this phrase of actual, implied, or apparent authority. So it's a matter of state law, but there is an example that the regulation Reg Z provides. So it includes, but not limited to, a transaction initiated by a person who has obtained the credit card from the consumer through fraud or robbery. So that would encompass that fraud piece of the coerced debt. Now, the coercion, it is unclear. Again, you'd have to look at your state law to see if there was actual, implied, or apparent authority. So if, for example, the survivor and the abuser are somewhere where an example would be if the survivor and abuser in a relationship, he like forces her, threatens her, requires her to give him the card, and then he has the card that he goes and then makes a purchase somewhere. The question would be if whether at the time he made that purchase with her card, the merchant or whoever had any reason to believe that the abuser had authority, whether implied, actual, or apparent. And that's a fact question. And so, there may be the ability to dispute coercion in that scenario, because it would really hinge on whether they had authority or not. If they were added as an authorized user through coercion, again, because they're an authorized user on the account, then there you're not going to have any remedy. They were authorized even if the authorization was obtained through coercion. So again, kind of summary talking about this, how do you evaluate whether the coerced debt meets the unauthorized use definition? Did they have actual, implied, or apparent authority? And what did the survivor do to indicate that authority? Did the survivor receive a benefit? So again, using the scenario of James and Maria, James forced Maria to open a credit card in her name for his use. When he uses it for a large purchase without her consent and without her being present, he tells the cashier it's his wife's card and he can sign for her. Does he have implied authority to use the card? So we know he doesn't have, actual authority because his name is not on the card, but does he have implied authority? Is that sufficient enough? Does he have apparent authority? And so again, this is all kind of state law, doing some research to see how other cases have come out. Could the cashier, and did they reasonably rely on the words or conduct of James? And did the survivor benefit from this purchase? So here's some case law on it. It is, there's the one here from Texas. It's an older case. It was Dillard's credit card. And here it was, I believe in this case, it was the husband of a wife who was disputing it. And they said, sorry, you're responsible for this. And it was essentially, they found that he was responsible just because he was married to the person. And so the decision is like, no, that's not enough. That's not a reasonable investigation. You can't just say you were married and that's why you're responsible for it. You actually have to show that that person used it and authorized it, et cetera. And then you have some other cases here. In the lumber case, I believe that it was the boyfriend of the card holder who went to this lumber store to make purchases. And there, they were like, no, just because you're in a relationship doesn't mean that the girlfriend allowed you to use the card, and that there was, authority there. So you can take a look at those. Some practical tips for the unauthorized use provision. Because unauthorized use under the general provision is also a billing error, they have to do the same thing. They have to conduct a reasonable investigation, even if they didn't, send the notice within 60 days in writing and comply with all the billing errors procedure. The creditor still must do an investigation, and the resolution is the same. They have 90 days to investigate and provide the outcome along with any documents requested, and they can't charge interest on those disputed transactions. So that was the Truth in Lending Act for credit cards only, so for coerced debt under credit cards. And now we're going to talk about disputing coerced debt, all coerced debt, any coerced debt under debt collection laws. So the first we're going to talk about is the federal law, and then we'll make note of the Texas Debt Collection Act. So the difference between the federal law, the FDCPA, and the Texas law is that the federal law only applies to debt collectors and debt buyers, but not original creditors. So again, just to use the example, if you have a credit card debt with Chase that then is sold off, and is, Chase no longer owns it, it was charged off or sold, transferred is what it would appear on the credit report to say, then the new owner may be collecting on it, that debt buyer, or a debt collector on behalf of the new owner may be collecting it through a debt collection calls, texts, emails, letters. That this federal law would apply to them. The debt has to be in default when it was sold, transferred, or charged off. A charge off is by definition, it's in default. But if it was sold, for example, an example of this would be an assignee of a loan for an auto loan. So technically, the original creditor on an auto loan is the dealer, but it's immediately transferred to the entity that's financing it. So if it's financed through like Toyota Motor Credit or through Chase or through a credit union, they're the assignee of that contract. So they're not the original creditor, but it wasn't in default when it was transferred. So they're not considered a debt buyer or a debt collector. So the FDCPA would not apply to them. The Texas Debt Collection Act, however, applies to original creditors and debt collectors and debt buyers. It doesn't have to be in default whenever it's transferred or sold. So it applies to everybody, which is great. It's just not as protective as the FDCPA. So the FDCPA, again, which is the federal law, it gives the consumer certain rights. And one of those really strong rights is to stop communication about the debt. So the survivor can request for, for all communication about the debt to cease, or a particular type, like do not call me, don't text me, don't email me, send me everything in writing by mail. Or don't send me anything in writing by mail, only text me or only email me. That's something that's newer under Regulation F that came out a couple of years ago. You used to have to request that information in writing. Now you can request it, whether on the phone or email or text, just saying generally, don't contact me anymore, or, don't contact me through this communication method. Then there also has the right to receive notice of the right to dispute the debt. So this is called the G notice. So in any debt collection attempt, they have to say you have the right to dispute your debt. And then they also have the right to request validation. And that's essentially like an investigation, like the other two statutes that I mentioned, where if you dispute it and request a validation, they have to investigate it for 30 days. They have 30 days to investigate it. The challenge is that the request for validation must be timely. So generally what will happen, it'll be 30 days from the initial date of the date of the initial communication. So if they get called on the phone, they get emailed or text, and that's their very first communication, they'll say you have 30 days to request validation. And then if after that 30 days has passed, you don't have that right anymore, but you still can dispute it. You can dispute it whenever. You don't have to, the dispute can be, the day before you get served a lawsuit. You can dispute it at any point in time. But the validation itself is a little different. It makes they have to provide certain information, like of how the amount of the debt and how it's obtained and all these different things. And then the law also, this is good for those that are defending consumers in debt collection lawsuits. The law says it dictates a venue for collection. So they have to be sued. The consumer has to be sued in the county that they live in, they reside, or where the contract was signed. Those are the only two places. It can't be where the defendant resides. It has to be, where the plaintiff resides. It has to be where the survivor resides or where the contract was signed. So again, they have the right to dispute the debt based on identity theft. The validation you see here, it has that 30-day deadline. But after that, you can still dispute it. And, again, similar to the other types of statutes we've talked about, I would include a copy of the police report, the FTC report, explaining that this is identity theft, and why, the consumer is not responsible for the debt, shouldn't be held liable, etc. After they've been notified about the fraud, about the identity theft, they can't sell or transfer the debt and can't place it for further collection. That's one of the requirements here. Often they don't comply with this, and that's a separate violation. But that, they can't say, you tell them, I don't know this, identity theft. And they're like, okay, well, we can't collect on this. So now we're going to sell it to someone else. So we're going to make a profit on it, sell it to someone else, when I know that this isn't a collectible debt because of identity theft. There's an overlap of debt collection laws and FCRA, so the reporting. If it, you see down here in red 1692 E8, it's a violation of the statute to provide false credit information. So if the survivor's disputing it, saying it's identity theft, and the debt collector does not report that it's disputed on the credit report, that would be a violation of the statute. So anytime you dispute it, whether it's through this law or through the Fair Credit Reporting Act, it has to say on the credit report, if it's not removed, if it's not blocked, it must at the very bare minimum say that it's disputed by the consumer. So what should be in the FDCPA dispute letter? Again, similar to other dispute letters, why you're disputing it, that you're disputing it, include copy of the police or identity theft report, request validation of the debt, request all documentations pertaining to the alleged debt. You can also request cease collection attempts. So say, in the letter, like, after you provide me the results of my dispute, then you cannot contact me anymore. Please stop calling me. Please stop contacting me. I would advise the consumer to keep a log of all of the calls, the creditors, letters, and all of this information, because it's going to be important for the 521 to list all that information. Again, after receiving that dispute, they have to stop any collection efforts while they investigate it. They can report the debt as in dispute to the reporting agencies, but they can't sell or transfer the debt. So that's kind of a summary of what I just had said before. Now, taking a step back and going to the Texas Debt Collection Act, which has to do with debt collection again, but this law applies to all creditors, all debt buyers, all debt collectors. It's not limited like the FDCPA. It's found in Texas Finance Code Chapter 392. And it includes a list of activities that, creditors and debt collectors cannot do in attempting to collect a debt. It does not provide the cease and desist remedy like the FDCPA or the validation dispute, but it does provide protection from harassment and deceptive practices. So some of those include, as far as like protection from harassment, communicating with third parties other than the survivor themselves, unless they're trying to locate the survivor. So the only reason they could contact someone else is say, hey, they can't tell them that they're collecting a debt or who they are, but they can just say, do you know contact information for a survivor? Is this the survivor? Is this their address? They can't communicate with a survivor if the survivor has a lawyer, or take action, threaten to take action they can't legally take, like threatening criminal arrest, saying we're going to put you in jail if you don't pay. This kind of goes beyond the scope of this presentation, but even though you can't really, they don't have to do the whole investigation and all of that. It's still, again, generally those creditors are going to be covered under, if it's a credit card debt, they're going to be covered under the Truth in Lending Act that we talked about. So you should still dispute with them. And if they're a debt buyer, debt collector, they may be covered under the FDCPA. So you should still dispute with them. So even though the Texas law itself doesn't provide those dispute and investigation remedies, as a best practice, I would go ahead and dispute with any party involved in collecting a debt that's a coerced debt. So here's another scenario that we could go through. So again, James and Maria, this is the same scenario that we've been going through since the beginning. James and Maria were dating. Without her knowledge, James got a new cell phone and started cell phone service for himself using her name because she had good credit. After she left him, she started getting collection calls for cell phone purchase and account she didn't recognize. So what legal remedies does Maria have? And what other questions would you ask? So assuming that you've done all of the screening with her and you've identified that this is an account that resulted from identity theft, whether it was coerced or fraud. And in this scenario, it seems fraud because she wasn't involved with it at all. And it was, through her former partner. Then you would have the identity theft remedies available um, uh, to everybody under federal and state law. So if it was on her credit report, you would want to ask those questions and pull the report and see if it's on there. So if the collections account is on her credit report, you have the legal remedies of disputing it or requesting a block under the Fair Credit Reporting Act. And then if, because it is a debt collection call that she's getting, if the debt collection is with if the debt collection company started collecting on the debt after it was in default, then you would have the right under the FDCPA to dispute the debt, to request validation, to request cease and desist, if that's what Maria wants to do. So you would have remedies under the FDCPA. All right, so this is the last part of the remedies for victims of coerced debt when it pertains to money lost from a bank account. So this is different. It's not a credit-related transaction. It is not, under the Fair Credit Reporting Act for a credit card or an auto loan or a payday loan or utility. It's not credit, it's money that a survivor had in their account that was then taken out of that account due to coerced debt. And the law that applies to this is the federal law, the Electronic Funds Transfer Act. It is found at 15 U.S.C. 1693 et sec. And it applies to consumer deposits and savings accounts, so bank and bank-like accounts, which means I'll go through it in a second, the type of accounts, but it generally, bank-like accounts means things like a Cash App account, PayPal, Venmo, things like that. And it provides protections for unauthorized use in other areas. The EFTA rights cannot be waived. That's found at 15 U.S.C. 1693L. And if you want to know more about what unauthorized use is and those protections, fantastic resource here is the CFPB's EFTA FAQs. For some reason, you can't click on that link. You can just Google, you can go to consumerfinance.gov, which is the CFPB's website. And on the search button, you can put EFTA FAQs and it will produce that document. So what types of accounts and transactions are covered by the EFTA? So as I mentioned, this is demand deposit, savings, assets accounts, but these have to be for personal, family, or household use. So it can't be a business bank account. It has to be a consumer bank account because the EFTA only applies to consumer accounts. It covers electronic funds transfers or EFTs, and EFTs are here. Here are some transactions. Sorry, one second. EFTs are electronic funds transfers, are generally defined as something that originates from an electronic terminal or some electronic transaction processing. And so it's not cash, it's not check, because those are all, those are paper. So it has to be electronic. The examples that are provided are ACH transactions and debit cards. So again, if you are, if the debit card's being used at the ATM to withdraw money, that would count. If the debit card's being used at a point of sale when you're purchasing something, you're using your debit card. Mobile peer-to-peer apps like PayPal, Venmo, Cash App, and Zelle. And prepaid and payroll cards, all of these are covered by the EFTA. The exceptions, as I mentioned, checks, because it's paper. If it initiates through a telephone call between the consumer and the financial institution, that would also be exempted. And then if it's a pre-authorized transfer, less than $100 million, and that, is kind of outside the scope of this presentation, because if it's pre-authorized, it probably wouldn't fit under the unauthorized use provision. But one that is really important here are wire transfers. So unfortunately, this is a loophole in the EFTA. Even though wire transfers are initiated electronically, back when the law was passed in the 70s, generally wasn't something that consumers used. It was more business to business. And then, they said they exempted it. It said wire transfers that are utilized through services that are not for consumer use. And then the Federal Reserve Board went ahead and in the implementing regulations, which is Regulation E, said that that includes services like Fedwire, SHIPS, and SWIFT. So pretty much all bank-to-bank wire transfers are exempted from the EFTA. But certain wire transfers, like if you see here on the slide, Western Union, MoneyGram, or even international transfers, which are called remittances, those actually are covered by the EFTA. There are some rules that differ if they're international, but if that happens, feel free to reach out to me or to TAP if you have questions about whether this you could utilize this provision or not. So it provides strong protections for unauthorized use. That then is kind of similar to all the other statutes, basically gives the consumer the right to dispute it, to have an investigation, and in this case, to have the money reimbursed or basically credited back to the consumer's account if it's unauthorized. So that's why we wanted to mention this, because if this has happened to a survivor, having money in hand is so important. And so being able to help them get money back that was taken by their abuser is a really powerful remedy and tool. So what's really important here to determine whether or not you can use this to help a survivor is whether the transaction was actually unauthorized. So the definition is written right here, and it has to be initiated by someone other than the consumer who does not have actual authority. There's no implied or apparent here. It's just actual authority to initiate the transfer, and the consumer received no benefit. So it has that similar language to the TILA's unauthorized use provision, that they could not have received a benefit from it. But again, if this was taken from them by the abuser, it's likely they're not going to have received the benefit of the money that they lost. And so the challenge here is if it was a joint account. So if the survivor and the abuser had a joint account, they won't be able to use this because he had actual authority to be able to take money out of that account, to transfer money out of the account because it was a joint account. So again, this likely will only happen in the scenario where it is the survivor's individual account that the abuser did not have access to, wasn't granted access to, wasn't an authorized user or anything like that. So important information about unauthorized use. These are in the FAQs, the CFPB's FAQs and Regulation E as well, which says consumer negligence plays no role. So if I, as the survivor, have my debit card in my wallet and I am very forgetful, and so I put my PIN number on a sticky note and then stick it to my debit card in my wallet, and then the abuser steals it, takes it from me and then uses it, I still cannot be held liable for that because consumer negligence plays no role. If it was unauthorized, then I have the right to benefit, of the benefits of this statute and the remedies that it provides. In this dispute mechanism for the error resolution procedures, the burden is on the financial institution to prove it is authorized. Unfortunately, in practice, they don't often get this right. So it necessitates multiple disputes and sometimes a complaint with the CFPB. But I can't prove a negative. So I can't prove that it wasn't me. It's on you to prove it was me. And so that's why it's so important when you dispute to ask for, information that they rely on in the investigation. If, if the money was taken from an ATM in Dallas and I live in Austin, then, they should be able to show that in their investigation. And I should be able to say, like, I couldn't have done that. I don't live in Dallas. I wasn't in Dallas. Prove that I was in Dallas, things like that. The CFPB does say that refusing to reimburse the consumer for unauthorized EFT initiated by a person who obtained access to the device through fraud or robbery is an EFTA violation. So that includes fraud. And so I would argue that if it was through manipulation or deception by the abuser, and it was, fraud in that sense, that it would be covered under the unauthorized use provision of the EFTA. The consumer receives no benefit. There's not very much case law on this at all. Part of that is because so many of these cases end up going to arbitration. But it is similar to TILA's unauthorized use provision. And so again, if most of the times you're going to be asserting this for coerced debt survivor is when they didn't receive that cash, they didn't receive that money, they obtained no benefit. But there's some examples here of the FTC where they, they unwanted skincare products that they got, right? Like they received them, but they received no benefit because they didn't want it. So debits for that can be considered not a benefit. So it may be fact specific if the abuser used it and obtained that money. You can argue that she didn't receive a benefit even if it was something that like he bought for her, but she didn't want. What is not considered unauthorized. So if it's initiated by the survivor, even if the abuser deceived or manipulated her to do it. So again, if in the context of there had, this happen where the survivor is the only person who is working, the paycheck is going into a joint account, and then the abuser says, you need to use that money to make a payment on a debt that was his, not hers. She's not liable for at all. But he says, you have to do this. Or if he himself, again, if he's an authorized user, makes a payment himself, there's no unauthorized use there because he's an authorized user, he's a joint account holder. But if he tells her, you need to do this, or I'm going to use, and she initiates the transaction, then she would not have the benefit of the unauthorized use. However, in that context, if he takes her debit card and initiates that transaction to pay off his debt, then it would be considered unauthorized because she did not initiate the transaction. The electronic funds transfer by a person to whom the consumer furnished the access device, even if it exceeds their authority. So this would be in the context of, again, the survivor willingly provide her credit card to the abuser to use it to purchase gas, for example. And then in addition to purchasing gas, he also bought himself some liquor and some food at the 7-Eleven. That would not be unauthorized because presumably she gave them that access device, and gave permission to the access device being the debit card, even if he exceeded the authority. The access device, as I put here, could be the debit card or even the account number, routing number information that allows them to initiate a transaction. But you can consider, even though under the coerced piece, it wouldn't fit the unauthorized use definition of, of the EFTA, you may be able to use the debit card abuse penal code provision if there was no express consent. You may be able to get a police report there and use that to dispute it with the bank. If the EFT isn't authorized, what then? So this is where the dispute procedures kick in, what are called the error resolution procedures. So there's all different types of errors. We're focusing on the unauthorized use. I've listed some other ones here. So you will then have to dispute it. There's no requirement under the statute of how that notice is given. So you don't have to send it in writing. It can be oral. Again, as with all of these, best practices to always send it in writing, follow up, because time is of the essence, dispute ASAP by phone or by going into the branch or whatever it may be, but then always follow up in writing. You have to dispute timely in order to be provided with credited your account back after that unauthorized use. So generally, if the ATM sorry, if the debit card wasn't stolen or the access device wasn't stolen, then you have 60 days of when you receive the statement showing the unauthorized use. So that would be, again, if to May 1, the abuser takes, logs into the account, does a Zelle transfer to his account, without her knowing about it or doing it her individual account, his individual account. I have from 60 days from May 1, because that's when, actually 60 days from when that statement with that May 1 charge appears. So generally statements are every 30 days. So it may be that the statement that has that May 1 Zelle transfer is May 15, maybe May 30th, maybe it's June 1, whatever that date is. Whenever it first appears, then it's 60 days from that date to dispute it. After you dispute it, they have to give you a response within 10 days. So they basically have to conclude the 10 days, the investigation within 10 days. However, they can take up to 45 days to investigate it, but only if they credit your account back that amount. So let's say it's $1,000 Zelle transfer that you're disputing. If within 10 days they don't conclude the investigation, they have to recredit your account that $1,000 while they're pending their investigation. So as you see here, even if you dispute it orally, they may require you to follow up in writing. This generally is what I've seen happen. And they may actually ask for more information. They may ask for a police report. They may ask for other things. But they have to tell you where to send it and how to send it at the time that you're disputing it. The notice, even though there's no, form required or anything like that, it does have to have enough information for the bank to do an investigation. So the account holder name, their number, the account number, which error it is, like, which charges it is, how it occurred, and the reason you believe it was an error. So in this case, the error is the unauthorized use. Although a police report is not required, and it's very clear in regulations that it's not required, they almost always ask for one. So best practice is to get a police report. But again, because time is of the essence, if you don't have one yet, I would encourage a survivor to call, to dispute, and then go get the police report afterwards and follow up with the police report. You want to ask for all the documents they use to investigate, again, to make sure that you have the same information that they have. So again, the liability issue, why time is of the essence. I said, if the device wasn't stolen, you have 60 days to dispute it from when it appeared on that statement, and you have zero liability on any of those unauthorized use of that $1,000 Zelle transfer if you report it within those 60 days. If you report it after the 60 days, so again, let's say that May 1 $1,000 Zelle transaction first appeared on May 15. You have 60 days from May 15 to dispute it. If you don't, then do it by that 60 days, and you do it 70 days afterwards, then you're not liable for that first $1,000 that happened on May 1st, but you may be liable for any preventable charges after those 60 days. So let's say the abuser does another Zelle transfer on, let's say the 60 days is May, June, July. Let's say the 60 days is August 1st. And so he makes a Zelle transaction on August 2nd, another $1,000 Zelle transaction, and I don't dispute until August 15. Well, I won't be held liable for the first transaction that was within those 60 days, but because I didn't do it within the 60 days, that Zelle transaction afterwards, on August 15th, I would be held liable for, because it was a preventable charge that I didn't just timely dispute. Now, if the access device was lost or stolen, so this would mean, for example, that the debit card was stolen, or I gave someone my account information, something like that, and then I learned, I then have 2 business days from learning about the unauthorized use to dispute it. And so, in order to make sure that I'm not responsible for that amount. If I do report it within 2 business days of learning it, then the most I can be held liable for is $50. So again, let's say May 1st, I realize that my debit card is missing. I check my bank account information online and I see that there was, $600 worth of transfers that were made when I first discovered this May 1st. So I have 2 business days from May 1st of when discovering my debit card is stolen to inform the bank about those $600 charges. And the most I can be held liable for is 50 days. If I don't report it within those 2 business days, but I do report it within 60 days of the bank statement, then the most that I can be held liable for is the $50 and any debits that are made after 2 business days until the notice is given. So again, in this example, May 1st, I learned of those $600 transactions. So I can't be liable for the $600 transactions if I report it within 60 days. I can only be held liable for $50 of that 600. But then if after I dispute, after, May 1st is when I learn of it, right? So May 2nd, I don't dispute it. May 3rd, I don't dispute it. May 4th, I don't dispute it. I don't dispute it until, June. Any transactions that happen after May 3rd, I would be held liable for up to a maximum of $500. So again, not liable for the initial 600, only liable for the $50 there. But then if after May 3rd, there's another $200, another $400, I could be held liable for that. Again, maximum of $500. So that's why time is of the essence. That's why it's so important to dispute this as soon as we find out about that. Again, worst case scenario, like you're like, I can't, this is too much. I can't even. Just to simplify it, if the consumer disputes it within 60 days of when it appears on the statement, whether the device was stolen or not, the most they could be held liable for is $50. So if the device was stolen, $50. Device wasn't stolen, $0. But that's only if you dispute it within the 60 days of the statement. And again, if it was stolen, they may have more liability, but that's only if more charges happen after the initial. So, that's a lot to think about, but at the end of the day, dispute as soon as you can. And, again, if you have, if this is difficult, you're not sure how to advise the consumer, feel free to reach back out to TAP. So practical tips, again, kind of bringing it back, notify bank as soon as possible. You need to do it within 2 business days if it's lost, or 60 days of receiving, for you not to be held liable for any charges, or the survivor not to be held liable. Can be by phone, in person at the bank. Make sure that the survivor puts the date, the time, location, employee that they talked to, the number they called, any of that information, so that, if there's any problems, you have that information to be able to provide to anyone, the CFPB, if you're filing a complaint with them. Best practice is follow up in writing. Best practice is also to help the survivor safety plan. So, that would be canceling a card, getting a new card issued. It may even be closing an account and opening a new account. It may be redirecting any deposits. So, if you don't want to close the account, but you don't want to, you want to order a new debit card, but you want to make sure that no future money can be taken from there, open a new account, have all new deposits in that new account, paycheck, things like that. So those are some things to think through. Just to wrap up, again, as I said, the bank has to report the results within 10 days or take up to 45 days, but only if they recredit. Again, the burden is on the bank and the investigation has to be reasonable. Again, I mentioned this before, but according to the CFPB, the bank can't require the consumer to file a police report or notarized affidavit. And they cannot require the consumer to try to dispute it first with the merchant before starting an investigation. but as a best practice to try to eliminate all the barriers as possible, often I will help the survivor do this anyway. If there was an error, then they have to correct it within 1 day. So after the investigation, they have to correct it. If they give provisional credit, but there was no error, they can reverse that credit, but have to give 5 days of notice of honor or payments for 5 days. And this may trigger overdraft. So what that means is, if they say they conclude the investigation in 45 days, they had given them provisional credit after 10 days, and that provisional credit was, that $600 unauthorized charge. If they conclude, sorry, you did authorize it, they have to give them at least 5 days notice beforehand. They also have to give consumer the written explanations of the findings, right to request those documents, and those documents have to be in understandable form. So I'm going to talk through this really quickly, which is the scenario. This is a little different from James and Maria. Susan was married to Ivan for 20 years. After the birth of their first child, he became emotionally abusive. After the birth of their third child, he became physically abusive. He lost his job, and Susan went to work as a custodian. He required her to deposit her paycheck into a joint account and prevented her from accessing the funds. When Susan fled for her safety, she opened a new bank account with the same bank, but only under her name. Ivan found out about the account and went to the bank branch and transferred money from her new account to the joint account. What legal remedies does Susan have? So here, because there's a new account that is only under her name, he's not an authorized user, he's not a joint account holder. How he found out about this account could have happened at the branch. He could have gone in and said, hey, my wife, you see, we're both on the account. However, he found out about it. If he then transferred that money using an electronic funds transfer. So again, if he did it through an ACH transfer through a, which is basically an account to account transfer, that he, if he logged on to his account and did that way, he was able to access her account somehow and to do that through her account, or even if he did it through getting onto her account and having that be sent to him through Zelle, or through he logged into PayPal and somehow had her account information, and so had that money be transferred from her new account to his. Like, if all of those examples that I'm giving is basically if it falls under the definition of an EFT, then she would have the error resolution remedies for unauthorized use under the EFTA, and she would be able to dispute it with her bank as long as she does it timely within 60 days of when it first appears on her account, and to have that money recredited to her account. So that was a lot that we talked about today, a lot of the resources that we talked about, during the presentation of the coerced debt assessment tool, of the drop-down menu for the types of accounts and next steps and who you disputed it and where, should be available on our website. But there's also other types of resources available. The Center for Survivor Agency and Justice has coerced debt screening tool as well. There is a listserv if you want, to talk to other lawyers who are helping survivors of coerced debt at talkcoerceddebt@csaj.org. And then we also, the Texas Council on Coerced Debt has a fantastic toolkit on coerced debt where you can get more resources and information. For example, our toolkit, which is on financialabusehelp.org, has 4 different tools on understanding what coerced debt is, protecting, discovering, and disputing. So all of the things that we spoke about today, there's sample dispute letters, there's checklists, things like that you can look through. So hopefully this presentation provided you with a lot of information to help survivors of coerced debt dispute their debts before applying for a 521 or even after applying for a 521. And you can watch that presentation on how to obtain a 521 with other resources that are available to you. If you have any questions, feel free to reach back out to TAP, or you can email me at csanchezadams@nclc.org.